Disclaimer: this video is for educational purposes only and does not constitute legal advice. Immigration law is complex, and individual circumstances vary. Before making any decisions about your visa application, please seek advice from a qualified immigration specialist. Akbar Immigration Law Chambers can provide tailored advice for your specific situation. We recently received a call during our free 10-minute consultation from someone with a really important question about historic overstaying and settlement applications. And I want to share this with you because many people are in similar situations and don't know what to do. Here's the question. The caller said, "I entered the UK as a student in the 2000s. I overstayed. Then I was granted my first visa under the family route in 2018. At one point, I switched over to the 5-year route and I qualify for settlement next year. Does part suitability affect me?" This is a really nuanced question, and the answer isn't straightforward. Part suitability and historic overstaying. Under part suitability, specifically SUI 11.3, an application for permission may be refused where the applicant is or has been in breach of immigration laws. And overstaying counts as a breach of immigration laws under SUI 11.4. Notice the word may be refused. This is discretionary, not automatic. That means the Home Office has the power to refuse your settlement application if you have a historic overstay, but they don't have to. What does this mean for you? If you have a historic overstay on your record and you're applying for settlement, there's a risk. The Home Office could refuse your application on suitability grounds. But it's not a definitive refusal. It depends on several factors. How long ago was the overstay? Was it one period of overstaying or multiple? Have you complied with immigration laws since then? How is your application drafted and presented? The importance of how you present your case. Because part suitability uses discretionary language, how you draft and present your settlement application matters significantly. A well-prepared application that addresses the historic overstay, explains the circumstances, and demonstrates your compliance since then can influence the outcome. This is not a case where you can just fill out the form and hope for the best. You need a strong, legal submission. The 10-year rule. Now there's another consideration. Under part suitability, if you have a breach of immigration laws and you're applying for settlement, the Home Office may apply what's known as the 10-year rule. This means you may be refused settlement unless 10 years have passed since the Home Office became aware of your overstay. For some people, this means waiting longer before applying for settlement. Article 8 and further leave to remain. Here's where it gets strategic. If you apply for settlement and the Home Office refuses you on suitability grounds, they may still grant you further leave to remain under Article 8. Article 8 protects your right to private and family life. If you have strong ties to the UK, family here, or a long period of residence, an Article 8 application for further leave to remain may outweigh the historic breach. So even if you don't get settlement, you may get further leave to remain instead. Settlement fees, further leave to remain. The key difference is this. For further leave to remain applications, Article 8 has more weight and the threshold is lower. For settlement applications, the Home Office has more power to refuse based on suitability grounds. This means you're more likely to succeed with an Article 8 FLR application than a settlement application if you have a historic overstay. The gray area. No case law yet. Here's the reality. Part suitability is relatively new in its current form. Until case law develops, we don't know exactly how the courts and tribunals will interpret these discretionary grounds. We don't know how strictly the Home Office will apply them in practice. This means there's uncertainty. Some applications will succeed, others will be refused. It depends on the strength of your case, how it's presented, and the decision-maker's interpretation. Critical. The financial risk depends on your route. Now here's something really important you need to understand. The financial risk of applying for settlement with a historic overstay depends on which route you're on. If you're applying for ILR under Appendix FM, the family route, if your settlement application is refused, but you're granted further leave to remain instead, you've already paid the very expensive ILR fees. But you will have to pay the immigration health surcharge on top of that. So even though you get further leave to remain, you've paid significantly more than you would have for a standard FLR application. This is a financial consideration, but at least you still have permission to stay and you can work. If you're on other routes, such as the skilled worker visa, the situation is different and much riskier. If your settlement application is refused, your only recourse is administrative review or submitting a fresh application for further leave to remain within 14 days of that refusal. And here's the critical part. While this second application is pending, you cannot work. This means you could be without income for weeks or even months while your fresh application is being processed. This is a serious risk that you need to consider very carefully before applying for settlement if you have a historic overstay. Strategic decision. Apply now or wait. So what should you do if you're in this situation? Here's the strategic analysis. Apply now if you have only one period of historic overstaying. It was a long time ago. You've complied with all immigration laws since then. You have strong ties to the UK. Your application is well drafted with a strong legal submission. You're willing to take the risk that you may get further leave to remain instead of settlement. You're on the family route, Appendix FM, where refusal still results in FLR without loss of work rights. You have financial reserves to cover the higher fees if you get FLR instead of settlement. Wait if you're close to the 10-year mark since the Home Office became aware of your overstay. For example, if you only have 1 year left before you complete 10 years, it may be worth waiting. You're risk-averse and want the safest route. You have other suitability concerns that could compound the issue. You're on a route like skilled worker, where refusal means you cannot work while a fresh application is pending. You cannot afford to be without income for weeks or months. Why some people should still apply. Even though there's a risk of refusal, some people should still consider applying for settlement now. Why? Because if the Home Office refuses settlement but grants you further leave to remain instead, you're not worse off in terms of your immigration status. You still have permission to stay in the UK. You can reapply for settlement later. And in the meantime, you're building more evidence of compliance and ties to the UK. For some people, especially those on the family route, the risk is worth taking. Why some people should wait, but if you're only 1 or 2 years away from the 10-year mark, waiting may be the safer option. Once 10 years have passed since the Home Office became aware of your overstay, your chances of success increase significantly. You'll have a stronger case and less risk of refusal. And if you're on a route where refusal means you cannot work while submitting a fresh application, waiting is almost certainly the better option. Don't risk your income and your livelihood. What you need to do if you have a historic overstay and you're planning to apply for settlement, Here's what you need to do. First, get specialist advice. Don't guess. Don't assume. Don't apply without understanding your options. Second, assess your individual circumstances. How long ago was the overstay? How long until the 10-year mark? How strong is your case? Which route are you on? Third, consider the strategic options. Apply now with a strong legal submission, or wait until the 10-year mark. Fourth, understand the financial and work-related risks. If you're on a route where refusal means you cannot work while submitting a fresh application, be very careful. Fifth, prepare a well-drafted application. If you decide to apply, make sure your application addresses the historic overstay and presents your case in the strongest possible light. If you have a historic overstay and you're planning to apply for settlement, book a free 10-minute consultation with us. We'll assess your individual circumstances and tell you exactly where you stand. We'll help you understand whether you should apply now or wait. We'll explain the financial and work-related risks based on your specific route. And if you decide to apply, we'll prepare a strong legal submission that gives you the best chance of success. Link in bio. Historic overstaying doesn't automatically disqualify you from settlement, but it does require careful strategic planning. Understand the risks, understand your options, and make an informed decision. We're here to help. See you in the next video.